We're taking you live to Sydney, where Executive Council of Australian Jewry co-CEO Peter Wertheim and Deputy President Robert Goot are speaking after a judge found Bankstown-based Islamic preacher William Haddad breached the Discrimination Act. Let's listen in.
When it became evident that the responsible authorities in Australia could not or would not act to protect vulnerable members of our community from hate-mongering, threats and violence, we decided that we had no alternative but to take action ourselves so as to defend the safety and honour of our community. That decision has been vindicated by the judgment that has just been handed down. It confirms that the days when Jewish communities and the Jewish people can be vilified and targeted with impunity are long gone. This case was not about freedom of expression or freedom of religion. It was about anti-Semitism and the abuse of those freedoms to promote anti-Semitism. People are free to engage in robust debate about international conflicts, whether their beliefs are true or false, informed or ignorant. But that does not include the freedom to mobilise racism as a polemical tool to promote one's views, to dehumanise and vilify entire communities or individuals on the basis of their racial, ethnic or ethno-religious identity. If the 300 ancestry groups and 100 faith communities living in Australia today were all free to vilify one another in the way that Mr Haddad vilified the Jewish people, the door would be wide open to chronic racial and sectarian strife of the kind that has devastated other countries, and the peace and harmony we have generally enjoyed in Australia would be ruined for everybody. Common decency should dictate that free speech and freedom of religion do not include the right to racially vilify people. Common decency should tell us that that is where to draw the line. But when common decency is lacking, as we have seen all too often over the last 21 months, then the law will draw that line for us, as today's judgment has demonstrated with crystal clarity.
I can just say, especially since October 7, the Jewish community has been vilified by many people, including that preacher of anti-Semitic hatred, Mr Haddad. We brought this action to protect the safety of the Jewish community and to uphold its honour and integrity. We've been vindicated by the court today. Mr Haddad's fundamentally anti-Semitic speeches, as we submitted, have been held to be unlawful. No community in this wonderful country should be dehumanised in the way that Mr Haddad treated us. Freedom of expression must not be abused by the promotion of hateful anti-Semitism. And those that wish to do so should know that that conduct will not be tolerated by us.
Speaking through his lawyer, saying that everything he said was scripturally referenced and therefore was allowable. How do you feel?
Well, I'd say two things in response to that. Firstly, as the judge pointed out in his judgment, all of the expert evidence about Islamic belief in the case, including Mr Haddad's own expert on Islam, said the contrary, said that Islam does not justify the wholesale vilification of Jewish people. So he's wrong about that. And secondly, even if a religious practice is mandated by one of the 100 or so religions that are represented in Australia, that doesn't mean that there's a wholesale licence to break the law. There are religions, for example, that sanction polygamy. Now, contracting polygamous marriages in Australia has been illegal for 237 years. And that continues to be the case. So the mere fact that a particular religious belief may or may not sanction a practice does not mean that one can go about breaking the law as it is. We're all free to campaign to change the law if we think that it's wrong. Everyone has that right. But what we're not free to do is to break the law. And that's what Mr Haddad has done. He's contravened Part 2A of the Racial Discrimination Act, and the judges found accordingly.
Are you confident?
Disparagement of Zionism is allowable because Zionism is a philosophy or an ideology, it's not a racial characteristic. What's the response to that it's okay to disparage Zionism?
We've always said that political criticism of the actions of the government of Israel or the policies of the government of Israel is entirely within the scope of ordinary discourse. Nobody's ever argued to the contrary. And, of course, the whole thing about Zionism was never really an issue in the case. We never argued it. It was never put by us or the respondent as an issue. So the comments that the judges made, to the extent that they referred to political criticism of the government of Israel from time to time, is not what this case was about. This case was about vilification of Jewish people in Australia.
But he did seem to find issues with the 3 lectures, but not with the sermon or the interview on that basis. Are you disappointed by that?
No, not really. I mean, it was very clear to us from the outset that the 2 of the speeches in particular were egregious. And we argued that the other speeches, although on their face were less obvious, if I can put it that way, they should be seen together with the entire series and interpreted in that light. So, I mean, I don't really think it matters. At the end of the day, the court has ordered that Mr Haddad and the centre that he represents be restrained from republishing comments that contain a whole series of imputations about Jews, including, you know, the infamous one about Jews being descendants of apes and pigs.
Are you confident he's going to respect that order?
Well, that is entirely a matter for him. I'm assuming that he will get legal advice that in this country, court orders are binding on everybody. It's the same rules for everybody. That applies to both religious practice and also obedience to court orders. And I'm just assuming that he will honour those court orders. If not, then we're going to be back here in a contempt case.
He has to pay costs. Have you got any idea what the costs might be?
Several $100,000.
Are you more disappointed that it took a civil case to get to this point and you tried to go to the
Well, it would have been preferable, really, for proceedings against Mr Haddad to have been brought by the state in the form of criminal prosecution. And we're disappointed that that was never tested, because we thought that there was scope for doing that, and it was never even brought to a court to be put to the test. So to that extent, I think the public as a whole has been let down, but as a fallback position, we've had no alternative but to defend ourselves, and we've done so, and the judge today has vindicated that decision.
Do you believe the outcome points to a need for stronger anti-vilification? Just to clarify, saying you have to bring this bill on your own?
Well, as I said, the original proposals for prosecution were never tested. Those prosecutions were never brought. So we don't know whether stronger laws are needed. But if the authorities believe that those laws were not sufficient to prosecute in a case like this, or in the case of the Opera House steps and the chanting of F the Jews and much worse, then clearly the laws are in need of reform.
Thank you.
Vindicated reactions from Jewish community leaders after a judge found that the Islamic preacher William Haddad did breach the anti-discrimination laws. Residents along the New South Wales coast are being told to prepare as wet and windy weather conditions are forecast to intensify. Let's chat live to Crystal Wu, who is in Wollongong, south of Sydney. Hi there, Crystal. What are the conditions like now?
Well, it certainly has intensified. The